Ankush Khardori, welcome to Planet America.
Thanks for having me.
So was this basically an inevitable verdict, do you think?
Pretty much. The evidence was fairly strong. Charges were relatively straightforward. There weren't really pretty robust lines of defense. So I was not surprised that the result was a conviction on all counts.
So what do you think of this trial? Were you happy with how the judge, the defense, and the prosecution all conducted themselves?
No, I was not, actually. I thought the defense did their job, a challenging job under the circumstances, given the facts, but I thought they comported themselves fine. I thought the judge oversaw the trial fine, but this is the same judge who also effectively blew up a proposed plea agreement that would have headed off this trial. That deal I thought was a very sound deal. She did not seem to like it and sort of scuttled it. And then the prosecutors, they brought a case that I think probably should not have been brought and prosecuted in some ways, and I thought some rather unseemly ways. So they got their conviction. I'm sure they can consider it that a win on their scorecard, but I don't.
I know some have argued that this case only ever went to trial because Hunter Biden is the son of the President of the United States. What do you think?
I think that's accurate. It's very, very rare for charges like this, and these charges stemmed from his purchase of a firearm. He was convicted of lying on that on a form that he needed to fill out to obtain that firearm about whether or not he was an active drug user or addict. He was also convicted of unlawfully possessing that firearm as an unlawful user of drugs or addict. But it's extremely rare for the federal government to prosecute charges like that solely on a sort of a standalone basis without more serious charges attached connected to a more serious criminal event. And I quite honestly have not seen anything like it. And I've seen no one identify any kind of precedent for this type of prosecution. It seems to have been one that emerged almost entirely because Republicans in Congress and Donald Trump himself were very upset about the deal that was on the table last year.
Now, a Republican would probably reply by saying that Hunter is lucky he's a Biden because that way he didn't have to face more serious charges, like, for instance, his lobbying career potentially leading to a breach of foreign agent laws. Do you think that's a valid view?
Well, look, 2 points. One is he's still facing charges in a separate case in California on tax fraud. So, he is facing additional charges above and beyond just these gun charges. And then I second on that particular point, this notion that there was a criminal case that could have been built up around his work with foreign governments and foreign entities. Those cases are much harder to bring and to successfully prosecute in the U.S. than people believe. In fact, the Justice Department has stumbled in this area in recent years, bringing cases that have not resulted in successful results. And, the notion that Hunter Biden could have been charged under a theory like that always struck me as somewhat dubious. It's been nearly a year since people raised those concerns, and the Justice Department does not appear from outward appearances to be headed towards any charges along those lines.
The star witness, in a sense, against Hunter Biden was Hunter Biden himself, Ankush. The audiobook version of his memoir was played at length, talking about his drug use in this period. None of that, of course, was sworn testimony. It was just an audiobook. Was that appropriate?
It was appropriate in the sense that, it was consistent with how the rules of evidence work in our legal system. If the defendant in particular provides some statements that are relevant to the case, the government can usually admit those into evidence against the defendant, even though they were not under oath at the time. So they're called admissions in our legal system, or statements of a party opponent. For better or worse, it is commonplace for statements provided by the defendant to be used against them. What is quite unusual, however, is for someone's memoir to be used against them. I've not seen that come up before.
What about the plea deal that Hunter didn't accept? It was just sitting there on the table. Why do you think he didn't take it?
I don't think it was a case of him not taking it. What happened is there was a plea deal on the table that would have required him to plead guilty to some misdemeanor tax offenses and to enter a pretrial diversion program, drug diversion program, to resolve the potential gun charge, but without actually having to be charged or be convicted. That deal made sense to me. What happened, however, when that deal was presented to the judge, was that she had some questions about the structure of the agreement, which was fine. Those could have been resolved. But she also had some questions about why effectively this would be the end of the investigation into Hunter Biden's conduct. And she asked as well, like, what about other charges and things like that? And that exposed or perhaps even created a fissure between the prosecutors and the defense about the scope of the immunity that was being agreed to. And once you have a dispute along those lines on a provision that is as crucial to a plea deal as the immunity provision, it's really hard to fix that fissure. So I don't think it was an issue of Hunter Biden not being willing to take the deal. I mean, he was prepared to accept that deal. I think it was an issue where the judge effectively scuttled it.
Sorry, Ankush, just to be clear, I'm not talking about last year's plea deal. I'm referring to a plea deal that was reported in the New York Times recently, which will have covered these charges and his tax charges, but wouldn't have allowed Hunter to have any other kind of immunity. That deal was apparently on the table and they didn't accept it. Why do you think that might have been?
There has been some reporting about the post-hearing negotiations about a potential deal that might have been on the table. I'm very reluctant, quite honestly, to read too much into that reporting. A, because it's been a little spotty and vague to my mind. B, it wasn't ever presented in court, so we don't really have anything tangible to look at. And C, I think the prosecutors here, based on my own observation, have been less than forthright about their position in all this. And the defense lawyers themselves, right? They have a client in their own interest. So I'm very reluctant, quite honestly, to read too much into like anonymously sourced accounts about potential plea negotiations. There's just a lot of messiness that you can read into it. So I'm just generally focused on the deal that was presented to the judge, which I thought was a perfectly fine and appropriate deal under the circumstances. Hunter Biden was prepared to agree to it. The judge didn't like it, and the prosecutors pulled it back.
So, Ankush, what avenues for appeal do you see for Hunter Biden here? To an extent, of course, this could go to a question of Second Amendment gun rights under the Constitution. Could this ultimately go to the United States Supreme Court to decide?
Yeah, I do think that is going to be a major focus of Hunter Biden's almost certain appeal, will be the argument that under our Second Amendment, these charges were unconstitutional, either sort of on their face or at least as applied to him, given the particular facts that emerged over the course of the trial about how he had kept the gun in a lockbox and facts like that may help bolster his Second Amendment challenge. And it's very possible that it could go all the way up to the Supreme Court. It is, in fact, an interesting little issue, one with perhaps broader implications for other types of gun laws. So I have no way of knowing, obviously, how that appeal will be resolved, whether it be resolved in Hunter Biden's favor or not. But it is certainly a very colorable and litigable challenge to this prosecution. But it won't surprise me at all for his lawyers to press it very, very vigorously. And it wouldn't surprise me at the end of the day if that argument actually had some legs, but we shall see.
Ankush, can you elaborate a little bit on what you found unseemly about the way the prosecution conducted themselves during this trial?
Yeah, so thank you for asking me that, actually. So I attended actually the first day of evidence, and I attended the opening arguments too. They were on the same day. And after the opening arguments, the government put on its first witness, and their first witness was an FBI agent who put into evidence Hunter Biden's book, which was literally the first exhibit that was introduced to evidence. In this case, was Hunter Biden's own book. And then the government proceeded to play 70 minutes of excerpts from Hunter Biden reading the audiobook version of his book, which is a very raw and evocative account of his time battling substance abuse and drug addiction, addicted, relapsing off and on over the course of years. And I found it very strange. And I think, again, quite unseemly. And I have to be honest, I never would have done it myself as a prosecutor, for the government to effectively use the memoir of a recovered drug addict against them in a criminal prosecution. There's something very odd about that. And then, after that, what the government then proceeded to do was put on sort of several witnesses, including his former romantic partners and his ex-wife, who were basically just sort of elaborating on aspects of the book. So what it seemed like to me is basically the government had his book. They decided they were going to prosecute him on the basis of along these charges, and then they just went and sort of shored up a bunch of witnesses from the book. I don't think that is a particularly impressive prosecutorial feat. I don't respect it. And I will just add one other sort of pretty salient detail from Tuesday that really stuck with me, was that The prosecutors informed the jury during opening arguments and then introduced this evidence over the course of the trial. Fact that was unknown to Americans, which was that Hallie Biden, who is the widow of Beau Biden, the son of the president who passed away some time ago, had herself been addicted to crack cocaine at one point as a result of her relationship with Hunter Biden. Now, I know that's a little sort of convoluted, but basically the upshot is the president's son's widow became addicted to crack cocaine as a result of a romantic entanglement with the president's other son, Hunter Biden. Americans did not need to know this fact whatsoever. It is a humiliating fact for Hallie Biden. It was not a fact that needed to be introduced in order to prove the charges against Hunter Biden. And it's just the sort of thing that I think a conscientious prosecutor would have been much more careful about. But this had all the hallmarks, quite honestly, at times, of an effort to humiliate the president and the president's family. And that is what they proceeded to do over several days.
Joe Biden has made it clear that he does not intend to pardon his son. But I wonder, do you think he might revisit that, particularly if he were to lose the election? He'd have nothing to lose, and he would be wanting to do everything he possibly could to keep his sole surviving son out of jail.
Look, I do think it's something that he might revisit, and so I wouldn't rule it out. The president was recently asked whether he would pardon his son. This was before the conviction, obviously, and he said no. However, a question that he did not get and did not answer is whether or not he would commute his son's sentence. So that is distinct from a pardon. Means you just basically wipe out the conviction and any sentence. Under our system, however, you can commute the sentence as the president as well, which means you leave their conviction intact, but you essentially wipe the punishment, so that if the defendant was in prison at the time, they go free. He wasn't asked about commutation as opposed to a pardon. I'm sure he will get that question at some point. But the upshot is that I do think that this is something that he could very well reconsider after the election, as you point out, particularly if he loses, at which point he kind of has a lot less sort of political skin in the game.
Now, I understand these are charges that would not normally be laid under these circumstances, but once the charges are laid and the person is found guilty, what are the chances that a person would normally face jail time from these charges?
You know, in this circumstance, I think they would be pretty good. I don't want to put a percentage on it, but I guess on one side of the ledger, you have the fact that, gun crimes in the US are treated very, very seriously. And federal prosecutors prosecute not this type of gun crime, but gun crimes generally a lot. They often seek prison time. And just given the nature of the offense and the guidelines, the sentencing guidelines that apply here, there may be a recommended prison sentence at issue here. The judge may very well impose a prison sentence. However, on the other side of the ledger, we have Hunter Biden. He's a first-time offender. He has children. He seems to have recovered from the addiction. And there doesn't seem to be any need to prevent him from obtaining another gun or deter him from any kind of similar misconduct. And I'm not sure it serves any broader purpose, societal purpose, to send him away to prison. So I think he would have a pretty good argument for probation and not a prison term. So I think it's going to be a real open question here, what the sentence ultimately is.
Finally, Ankush, do you think David Weiss was the right person to appoint as special counsel? Conservatives are of the view that even though he was originally appointed by the Trump administration, he was often a political operator. Do you have a view about that?
Look, David Weiss has become a weirdly complicated person on the right. I mean, he's a registered Republican. He was unanimously confirmed by the Senate during the Trump administration. He was appointed by Donald Trump. I mean, this is a Republican. And the notion that he got sideways with Republicans on any principle basis is frankly a little absurd to me. That is not what happened. They didn't like the result. He's not some bad Republican. He's not a bad conservative or anything like that. They just didn't like the proposed resolution he put on the table, which, as I said, I thought was a perfectly appropriate one. I think the problem with, or at least the criticism I would have with David Weiss, has nothing to do with echoing the concerns of conservatives, which are, I think, are wildly geared political attacks for the most part. I don't think this case should have been brought. That's my problem. I don't think this case should have been brought. I mean, the tax charges, those are a separate sort of bag. I also think those are sort of on shaky ground as a matter of prosecutorial discretion. But I'm less interested in the conservatives' critique of David Weiss at this point. The trial is over now. The verdict is in. We've seen the prosecution they put together and the way that he and his team comported themselves. So I have a criticism of David Weiss is that he brought this case and that he conducted himself and his team conducted themselves the way that they did.
Ankush Khardori, thank you for being with us on Planet America.
Thanks for having me.